this case just got serious. A lawyer asks for more time, saying he's not ready. The judge pushes back. Give real reasons! The defense claims the money wasn't illegal, but part of a legal deal.
I've had a request for one additional question from Mr. Ivey, and then Ms. Henson wishes to make a statement. So, Glenn, you're recognized. You go ahead.
Okay. Thank you to both of you. I want to see if I can tease out where we are with respect to the stay versus continuance. So the stay, I think we've kind of argued past that because just the length of time and the issues that are raised with respect to the Fifth Amendment challenges and the like. The continuance piece, though, let me ask why do you need additional time? And I want more specific than there's a lot of documents out there and I need time to go through them. What exactly would you like to try and do to address the issue with respect to disputes with respect to material fact that would be relevant to the motion for summary judgment? What exactly are you trying to do, and how little time could you do that in?
Thank you, sir. The very first thing I would do would be to sit down with my client and come up with a list of witnesses to interview, to offer.
I don't want to get in your attorney-client privilege piece, but I bet you've done that already, right?
No, I haven't.
Haven't had a chance to do that with her?
So I've had the case for 2.5 weeks. We have not arranged for witness interviews.
Not witness interviews, but just with respect to talking with her about what time. Okay.
No, we've talked, but I need to get people into the office. I need to set up interviews.
All right.
We need to work on the case. We need to go through the documents and prepare responses. None of that has been done, not really.
All right.
We did our best in 2 or 3 hours to put something together, but she deserves a real response to this motion, and in order to do that, it's going to take time.
Okay, and then the documents that you did attach to the motion you filed, I think these are the documents you attached. Can you tell me briefly what the relevance? You got an affidavit. I saw a notice of a settlement agreement, if I recall correctly. There was a document on there that was too small to read for an old eyes like mine. What are the points that are raised in those documents that would be relevant to the motion to dismiss?
To the summary judgment motion.
Yeah, I'm sorry.
Yeah. First, you have an affidavit in there that is contradicting evidence that staff was relying on in their summary judgment motion, saying that that did not happen. I was a witness to that, and I saw it differently. So that is a conflict in
what is that?
The specific disagreements?
I mean, it doesn't have to be all the way in the weeds, but give me a general sense of what the disagreement is.
Disagreements about why money was moved, for example, from one account into another, how loans were made, who was responsible for directing those transfers of money. You have staff has a witness who's claiming that the Congresswoman purposely put money into an account and then withdrew it in violation of FEC rules and regulations. And my understanding is the witness is going to say that that's not what happened. The congressman never directed that for it to happen that way. It was done by another individual.
Is that the affidavit, or is that?
That's the affidavit. Okay. I mean, I mean, to be honest, this is part of this is just having the case for 2.5, 3 weeks.
I'm not trying to pick it apart. I'm just trying to figure out what the documents were and the relevance of those to the motion.
Yeah, the other things that we attached was the fact that many of the complaints that have been alleged by staff were also investigated by the FEC. And they had to do with the fact that the Congresswoman's, for example, the most recent ones, you know, maybe her first successful election, and having volunteers handle things like financial reports and not having a professional compliance team on board. So lots and lots of different mistakes were made, and a lot of those mistakes are reflected as complaints of the violations. The information.
That's the settlement agreement, the FEC settlement?
There was a settlement agreement where the FEC referred the Congresswoman to alternative dispute resolution, indicated that she needed to hire professional compliance staff in the future, that somebody had to undergo remedial training on the necessity to file certain financial disclosures, all of which has been done.
Okay, and then that document that you have there is some kind of a, it's too small for me to read, but it was like a spreadsheet. What is that?
It's huge. That's the most important document, and that's a document that unfortunately touches upon the criminal case, which is one of the reasons why it's troublesome for me to get into it. But one of the major allegations that staff has made is that Trinity Health Care Services funneled money illegally into the Congresswoman's campaign, and that the Congresswoman was just taking money from Trinity and using it for her campaign. Nothing could be further from the truth. One of the things that we filed so that the committee has it in front of them is the fact that she was entitled to a certain percentage of profits of Trinity, and the money that she was receiving from Trinity was not money that Trinity was using to finance her campaign. It was money that was legally obligated to be paid to her as part of the profit-sharing agreement, and those are the documents that were presented.
And I know I appreciate the indulgence of the chair. Could I ask counsel for the committee to respond to what they've heard? By all means.
I think much of what Representative Cherfilus-McCormick's counsel has raised goes towards the motion to summary judgment, and we're happy to address it in that context. To the extent that he is raising a new motion seeking some additional time, a continuance of a couple weeks, while that is procedurally improper, we're not objecting to him raising that now. And we wouldn't object in theory to the idea of a little more time, but we would raise some concerns about that concept. It's a little unrealistic given the realities of the House calendar and scheduling things. And then the blackout period that's been referenced would start in, I believe, on June 24th, 60 days prior to an election in which the respondent is a candidate. The process that we're undergoing is more than just one day. This involves a adjudicatory hearing at this time, but provides for a sanctions hearing to follow, and then likely a resolution for the entire House to consider. I think that the reason why we are here now at this time is because this is what puts the House on track to consider this in a timely manner before that blackout period begins.
Thank you, Mr. Chair.
Gentleman yields back.